All right, so we'll get started as folks trickle in. Hi, everyone. My name is Derek Rice, and I'm an editor at the LPE blog. Thank you all for joining us. As you know, we had hoped to gather in person last April for the Democracy Beyond Neoliberalism conference. Nonetheless, over the last 5 months, we have been so grateful to the LPE community for making the virtual version of this conference such a success. Today's panel is the finale of our panel series that started in December. Videos of past events, as well as our ongoing conference blog symposia, are available through our website, lpeproject.org. We will have one additional event next month titled Critical Theory and Law Reform, Past and Future. The event was postponed due to unforeseen circumstances, but we are working to reschedule and will announce a new date shortly. Now it is my pleasure to introduce today's student moderator, Cal Barnett-Mayotte. Cal is a 2L at Penn Law and a co-leader of Law Students for a Democratic Society, Penn Law's LPE group. Take it away, Cal.
All right, thanks, Derek, and welcome everyone to today's panel discussion on LPE, inclusion, and public law. We have an all-star panel, and I'm super excited to learn from them. So I'm just going to post their bios in the chat in case anybody's interested in their backgrounds. They are, of course, Professors Amanda Shanor, Reva Siegel, Deborah Dinner, and Swethaa Ballakrishnen. I think we want to get straight to the discussion, and it would take too long to introduce everybody adequately. So I'm just going to go over some logistics and hand it over. We plan to leave about 20 minutes at the end for Q&A, and I think our panelists are hoping for a lively discussion. So please feel free to place any questions that you have in the Q&A function, not the chat box, the Q&A function whenever they arise. And you can also upvote any questions that you're particularly interested in having addressed. Also, we encourage audience members to introduce themselves in the chat box to make this feel a bit more communal. So with that, I'll pass it over to Professor Shanor to get us started.
Terrific. Welcome, everybody. It's really a pleasure to be here with you all today and with this terrifically brilliant panel. As Cal said, my name is Amanda Shanor. I'm an assistant professor at the Wharton School at UPenn, and I have the pleasure of opening our discussion today. In my brief opening remarks, I want to give you all some background about law and political economy and its relationship to public law, both as a framing for our discussion and to tee up a sort of like set of questions and puzzles. As many of you know, the law and political economy movement, or we might think cluster of thinkers and ideas, began as a response to the really many crises of our present moment. And I put a paper in the chat. If you are interested, I would highly recommend it. And those folks identified and centered accelerating economic inequality in which gains at the top of the spectrum, really a small sliver of the elite, have wildly diverged from the rest. And they argued that this shift has profound implications for our politics, for our democracy, for lived and meaningful understandings of freedom. And this shift is central to the challenges of eroding democracy, the climate and public health crises, rising illiberalism, and the carceral state. The crucial insight on which LPE thinkers converge is the recognition that law is central to how those crises developed, and that we will have to reorient law if we're going to do anything to combat them. One of the key moves made by this group of really exciting, mostly young, some radical scholars, is that there's a false divide within law and legal thinking between private fields of law, such as contracts and intellectual property on the one hand, and public law, particularly constitutional law on the other. And in this critique, private law, principally under the influence of classical law and economics and the law and economics movement, has reified the market as something apart from law with its own natural, even maybe neutral workings in which efficiency rather than distributional or other normative concerns is the paramount, indeed maybe only value. While for its part, public law has tended to ignore questions of the economy, those of economic power and economic inequality. And indeed, public law in many contexts has facilitated many of the crises of the present. In many ways, in my view, LPE is at core a response to classical law and economics framework, and how it and neoliberalism have shaped and been facilitated by law. So given the really interesting and import of these ideas, I think it's no surprise that LPE has really caught fire in the private law scholarship, including scholars exploring, how law and the state are always already managing and structuring markets and making distributional and normative choices, not natural ones. Scholars have excavated how private law has structured and aided the consolidation of economic and political power, in areas from intellectual property to environmental law, antitrust, of course, and beyond. A lot of those scholars seek to revive and reimagine legal realism and basically the ideas and responses of the first Gilded Age, right? So following certainly in the context like the Great Depression, for the informational economy of the second Gilded Age where we are now. So that's a bit of a tiny sliver of the rich and nuanced LPE private law domain. We are much more at the beginnings of thinking through public law and LPE. But there's been an exciting spark of scholarly interest around certain questions within public law that I want to highlight, including prominently really big things that have been happening in the First Amendment and its arguably Lochnerian turn. Specifically the way it's become the central situs of conflicts between the Constitution and economic regulation. And there's been really great and cutting edge work on this front. Folks like Genevieve Lakier or Tim Wu, Robert Post. There's also been a blaze of work in administrative constitutionalism, particularly terrific historical work by scholars like Sophia Lee and Gillian Metzger, essentially rebutting the contention that concepts of laissez-faire constitutionalism, which are currently being championed by certain conservatives, okay, so like ideas principally of classical law and economics, that they were actually what the founders believed, okay? So should be adopted in an originalist framework, basically. And of course, there's been field altering work in antitrust, which really sits in many ways at the cusp of the public and private dimension. Distinction. So let me step back and thematize or bucketize this literature a little bit. First, we have sort of like a group of scholars that have focused on the way in which public law totally ignores or has facilitated aspects of growing inequality. So for example, Aziz Rana has explored how conversations in constitutional law, including our 1L curriculum, don't include the insular cases and the role of settler colonialism in shaping our constitutional present. Similarly, we could argue anti-discrimination law doesn't own or acknowledge the redistributive dimensions of the relationships it regulates. And as I said before, the First Amendment has really been a key aider and abetter, right, of many of the deregulatory problems of our present, including in campaign finance. So that's one area. So sort of like, ignore or facilitate growing inequality. Other folks have explored how economic changes, economic movements, and other economic ideas have come to structure and be embedded in public law. Okay. I, for example, have work on the role of the business community in something of a social movement shaping the currently ascendant libertarian ideas of the First Amendment, and specific how the sort of central concept of liberty and freedom within the First Amendment now mimics ideas of market freedom in a sort of like hollow and I think really impoverished way. Okay, so those are the two kind of like big buckets, I'll say. Again, some folks have focused on the way that public law ignores or has facilitated growing inequality, and others have excavated how economic changes, economic movements, and economic ideas have come to structure public law. But like I've said, more broadly, the scholarship on public law and LPE is really at its beginnings, where the private law side has really outpaced its public law dimension. And I want to set up a few questions that I think in elaborating this conversation we'll need to confront. These are questions like, how should we reimagine concepts like democracy or freedom or rights and their relationship to social and economic power and inequality? How should we consider questions of gender, race, and other status inequalities? Do we need to think beyond Western frames and specifically American constitutionalism and its focus on courts? To what degree do we need to think beyond the problems and pathologies created by law and economics? How should we think about the nation state or polity in an ever-connected, ever unequal world? Okay, so that's all to say, hopefully for a little bit of background, but we're at the start of a conversation, not at the end, which I think is really exciting, both for future work and the topics that we're going to explore today. And the amazing scholars we have on our panel have worked and long worked on projects that intersect with these ideas and themes within LPE. Each of us works in areas that we hope will expand, perhaps even challenge the burgeoning conversation around LPE and public law. Okay. So that's a framework I'd like to start us all off with. And now what we're going to do is we're going to have each of us say some stuff about our own work and how we connect to LPE. And then we're going to have a conversation that hopefully puts in conversation the ideas that we each bring to the table. Okay, so as Cal, I guess maybe as maybe he linked the thing. I guess we didn't get an introduction. I'm a First Amendment scholar. And in a set of projects, I'm exploring and trying to reimagine the First Amendment, both what it should mean and how we can pull it away from its current destructive path to one that supports more meaningful democracy. Today, I'm going to focus on one project about social media, through which I hope to make a larger point about how I think we should think about democracy and the public-private distinction. As you all are certainly aware, we're no longer in the heady days of the tech boom and the idea that the internet would bring a more democratic, egalitarian era. The tech giants now dominate our public spheres and our economies and our attention. And social media has become synonymous with mounting threats to democracy and growing polarization and rising inequality. In response to these threats, two principal scholarly and policy debates have emerged. The first, there's antitrust. A growing number of scholars and policymakers have called for the breakup of the technology giants, as a or maybe the solution to these problems. One of the sort of big ideas that they turn to is that trust busting and other tools of anti-monopoly regulation were key to addressing the challenges of the first Gilded Age, and they're needed today in the second. Right? So as one historian explained, our worries about our technological future are sending us back to the solutions of our industrial past. So that's antitrust. The second debate centers on whether and how the First Amendment and free speech values will structure the digital public sphere. In this context, a group of scholars most scholars, I'll say, have decried the Constitution either as an obstacle or obsolete in the face of the pressing challenges that we see today. The First Amendment is an obstacle, they say, basically because in its robust libertarian form, it arms companies with a really potent weapon to fight all manner of regulation, from privacy rules to confronting trolling or threats to democracy. At the same time, other folks, I'll say like Tim Wu argue, Jack Balkin, that the First Amendment is increasingly obsolete, in part because of the arcane state action doctrine, under which hopefully you learned in constitutional law, the Constitution applies only to state action and not to private entities like social media platforms. Okay. In the project I'm working on, I argue that the responses of both the antitrust on the one hand and the First Amendment literatures on the other ignore and ally the role of collective voice in building countervailing power and decisional legitimacy within private power. Basically, these literatures assume that the solutions to our current crises come from government or will come from government, and that the space of democracy is sort of in reference only to governmental action. In so doing, I think that they accept a public-private divide that naturalizes the idea that we shouldn't have a say at work or over the rules of privacy or our data or the money that's drawn out of us through the monetization of our online lives. I think they ignore the importance of social relationships and social reproduction in contexts like workplaces and Facebook, both central sites of the construction of social and economic power, now wildly unequal, and also norms of democracy and speech. Okay, so by focusing on this missing piece in the two dominant conversations about big tech, I hope to illuminate both a possible avenue for tech reform and a path to reimagine the First Amendment. Sort of like the bottom line is that I think rather than or in addition to breaking up big tech or regulating it, we need to think about democratizing the tech giants. Okay, so how is this a constitutional issue and how does it intersect with law and political economy? The Supreme Court has long heralded the First Amendment as the guardian of our democracy, but of late, it's really understood that democracy in an impoverished, really hollow, formalist way. And what I do, or what I argue, is to build off a long history of thinking and scholarship in industrial democracy and philosophers like Elizabeth Anderson to think more materially about freedom and democracy in the private sphere, right? And what I want to put forward is that we should adopt a thicker notion of democracy, not just about elections or ballot boxes, but participation in the important social institutions that decisionally and materially structure our lives. I think we're really at an exciting and important inflection point in both First Amendment history and tech governance. And at this moment, I think that the terrain is ripe for one or more social movements to arise to demand democratic accountability from big tech, as something like a hybrid consumer democracy movement. And those movements could seek increased decisional power, like user input into platform policies, or like earlier labor and industrial democracy movements. They might demand forms of economic participation as well. The current court, I'll say one of the other things, like I'm a former litigator, and I'll say I don't think that there's much opportunity now at the current court to turn the First Amendment away from its like really radical libertarian tear. But I think we're in a position right now that social media policy and practice are in a position to shape the future, not only of the freedom of expression online, which is what a lot of the focus has been on, but of the constitutional culture of the First Amendment and its relation and the relationship between speech and democracy, and how people think about and experience what that means. And the hope is that those things, if they're built well, might also flow back into doctrine and even invite new doctrinal horizons. So that's what I'm working on now, and I'm happy to hand it off to Reva.
Great to hear you talk, Amanda. All right, so I'm going to shift grounds reasonably dramatically to another sphere that is not necessarily as commonly thought of as the terrain of public law, but we'll, at the very end of things, see if we can get back there. So right now in Washington, the Biden administration is looking for bipartisan support for a $2.3 trillion infrastructure bill. And the Republican Party is opposing the cost of the bill and arguing about what kind of infrastructure the country should be paying to invest in. It's right now they're bargaining over whether we should be covering what's called conventional infrastructure. Joe Manchin is talking about, well, we can cover bridges and roadways and sewers and the sort of thing that can be repaired and fixed, but not this human stuff. But the Biden administration, Cecilia Rouse, who's the first woman, actually a woman of color now leading the Council of Economic Advisors, is actually defending the administration's plan to spend $400 billion on the care economy as part of infrastructure. And she made an observation. She said, many people think that care workers or the home care sector, that's not really infrastructure. She's essentially echoing back what she's hearing in DC. But she says she begs to differ. I can't go to work if I don't have someone who's taking care of my parents or my children. And so here we have a conversation about what counts as infrastructure for the economy. And as I think even this brief discussion makes clear, markets have infrastructures of many kinds. We are reasonably adept at identifying what Manchin is calling the conventional infrastructure, roads, phone lines, sewage treatment plants, less so clear about identifying the less conventional human ones. That really points to a paradox of infrastructure of the kind that we're talking about here, that neither law and economics nor LPE has really developed much of an account of in a way that reflects, I think, the politics of the care economy in our larger society. When we talk about the care economy, it's inflected with work we associate with love and altruism, but work at the same time that we devalue and disrespect and disappear at the same time. All of these things are going on all at once. Very complicated and hard to pin down processes of valuation. I want to say that one of the reasons why this is in play in the administration right now is because women of color who work in the relevant industries here are part of the Democratic coalition that elected Biden, and they had the leverage to put this on the agenda for the first time. But also because of disempowerment of the relevant communities, the work has been valued in the ways that it is. There's a kind of paradoxicality that at root here. And in some of the work that I've been doing really at various points in my career in various forms, I've tried to trace relationships between political authority and the marking of this work and its valuing in different bodies of our law. And I want to talk briefly now about work that I did at the point of the centennial that marked or traced the valuing and the disappearing of arguments over the work in question, both in its paid and unpaid forms, which is the work that the work in the care, the form that the work in the care economy takes. So just to do a bit of a mashup drawing on some of this work, now I'm talking about a piece that travels under the name The 19th Amendment of the Democratization of the Family, which I published in 2020. At the point of the ratification of the 19th Amendment, Crystal Eastman, one of the founders of the ACLU and of the International Peace Movement and a socialist and an altogether fascinating early woman lawyer, gave a speech in 1920, and now we can begin, in which she said the vote was only the first step in attaining women's freedom in the feminist sense. She said that in 1920, there would be, she proposed an additional 4-part plan, including pursuing an end to barriers to women's employment, a revolution in early training of boys and girls, saying that we must bring up feminist sons, is the way she put it in 1920. She said we needed to pursue voluntary motherhood in the law, seeking birth control, which she said was essential to freedom of occupational choice and as elementary as equal pay. And she also sought a motherhood endowment, which she saw as state support for those who are raising children so that they wouldn't be dependent on men. So she was trying to solve the question of care work and the question of what the movement called pecuniary dependence in 1920. At the same time, she was also dealing with the issue of care work. Others in the movement were trying to theorize ways of coordinating care and paid and unpaid care work. In making this proposal, she is tapping on forms of argument that proceeded from even the years before the Civil War. The movement had been saying that women needed enfranchisement in order to challenge forms of law that would alter the ways in which they performed the work of social reproduction. That was a reason they needed the vote, and she was tapping and saying that this was a way to exercise the vote. In the 1840s, there were claims for voluntary motherhood, including a wife's right to say no to sex. They also focused on questions of support for the work of family care. By the turn of the century, Mary Church Terrell, the founder of the National Association of Colored Women, was already beginning to build forms of public kindergartens and childcare for forms of racial uplift. This was also pursued in various forms of what was called social housekeeping, which is the beginnings of building out the idea of care work in the state. Now, I'm just going to leap forward by a half century and say that at the half century anniversary of the suffrage, the movement was at the same time making structural arguments for equal citizenship. The memorialization of the suffrage, I'm going to just wrap this up quickly, was calls for childcare, not just an ERA, but childcare. These are the same calls that we're facing today. They were advanced in the 1970s, just as they were imagined in the 1920s. And this is what I'm putting on the table now. People who lack the social position to leverage the kinds of claims that Elizabeth Warren and other people in the Biden administration are putting on the table now, we're putting them in play 100 years ago. So this is to remind us that the structure of our public and private institutions are themselves the expression of public power, and the ways that we model what counts as public and what counts as private, what counts as the family form, and how we understand the forms of the economy can't be neatly divided into the public and private, and are themselves the expression of what counts as democracy. And the reason I chose this paper to throw into the mix is that it troubles the divide of what counts as public and private law here. And it reminds us that the people had the power to decide what counted as a market were the people with the votes. And I'll stop there.
Okay, so my name is Deborah Dinner. I'm a legal historian of gender, work, and the welfare state. And my kind of remarks today pick up historically and chronologically where Reva's left off. And speaking of care work, I should say that extends to the academy too. So I'm going to speak about a project that I got my start on as an RA for Reva. I won't say how many years ago. So thanks to LPE and my wonderful co-panelists. Today, I'd like to discuss some research from a forthcoming book I have called The Sex Equality Dilemma, Work, Family, and Legal Change in Neoliberal America. So the book argues that the last third of the 20th century was marked by a sex equality dilemma. And by this, I mean, how should law and policy regulate the intersection of motherhood and women's labor market participation? So the book examines debates about this question between feminists and social conservatives, workers, union leaders and employers, state and federal politicians and judges, roughly from the passage of Title VII of the Civil Rights Act of 1964 to the Family and Medical Leave Act of 1993 and beyond. And I argue that feminists pursued dual goals. So one is the one we more commonly think of, the individual freedom, employment opportunity, individual rights, the elimination of gender stereotypes as imposed by the law. But a second set of less commonly remembered goals were ones that centered social reproduction. And by this, we mean the replication of the next generation, quite simply, the resources, the labor, the care that's necessary to raise children, sustain people across the life course, and care for people in their old age and when people are sick. So feminists fought for a more robust welfare state that would support social reproduction. And they pursued such support along three axes. One was making the workplace more accommodating of working parents, so things like parental leave. Another was economic justice for paid caregivers, so protective labor laws, fair pay, just work conditions for everyone from home health care aides to childcare workers. And the third axis was state support for unpaid caregiving in the home. And my argument is that feminists, however, made greater strides towards advancing sex discrimination law, although we still have a long way to go. And we always have to fight against retrenchment in that arena. But they made greater strides in that arena than they did their goals for a more robust welfare state. And the book explores why and the consequences of that asymmetry. So just to kind of give you an overview of why, I argue that we need to focus on employer and market conservative arguments against feminists, as well as social conservative ones, that the fusion of market and social conservatism in the Republican Party in the 1980s played a huge role, and that finally courts' hostility to the redistributive potential of anti-discrimination law also was a third and important causal factor. So as a result of this kind of asymmetry in the institutionalization of feminist goals, by the 21st century, you have a neoliberal interpretation of sex equality. So one that focuses on individual freedom and the elimination of gender stereotyping, but that maintains private responsibility, familial responsibility for social reproduction, one that disproportionately falls on the burden of racialized paid care workers, as well as the unpaid caregiving of women in the home. So I want to illustrate this kind of very briefly by focusing on two historical episodes. One is from the late 1960s, and it concerns the fate of maternalist labor standards. And then the second is from the mid-1970s about questions about how to value unpaid caregiving in the home. So really quickly, in the late 1960s, after the passage of Title VII, one of the central debates was how should Title VII affect maternalist labor standards? So these were hours that regulated the hours or laws that regulated the hours women could work, the way they could lift, imposed other kinds of restrictions and benefits on women, and they proliferated in the progressive era. And initially, there was really a divide within the women's movement. So some feminists, I focus on a woman named Myra Wolfgang, really paid attention to the protective nature of these laws for women who weren't otherwise protected by collective bargaining agreements or by federal labor law. And other feminists focused on the very real discriminatory effects of these laws. But what I really want to focus on today is that there was potential for a united feminist vision, and that feminists on both sides of these debates came together to extend state-based protective labor laws to men. And this was what I argue that was the most transformative vision in this debate. It was one that married or fused the progressive and New Deal era commitment to labor protection with a new civil rights era commitment to eliminating gender hierarchies. And it used sex equality as a way to serve as a catalyst for expansion of the welfare state through protective labor regulation. But that moment was largely lost. I won't go into the details why, but I think it's a moment we should return to, both in terms of historically understanding the precarity of work today, but also in recovering a vision of state-based labor regulation that holds the potential to meet some of the gaps in an increasingly anachronistic system of federal labor regulation. Okay, so another historical episode that I want to describe really briefly is the one that focuses on the question of women's unpaid caregiving labor in the mid-1970s. And I just wanted to contrast or bring up the varied feminist response to the structure of the welfare state, which was organized around a family wage ideal, that of a male breadwinner and female caregiver. One response, most famously, was pursued by Ruth Bader Ginsburg and other feminist attorneys, and that was to open up within the welfare state the role of breadwinner and the role of caregiver to both men and women. So it was to eliminate gender stereotypes under law. And another and concurrent, and I think really compatible response, was to enhance benefits for caregiving, and at the same time liberate women from the heteropatriarchal families. So one example of this would be Social Security credits for homemakers. Another even more aspirational example would be the Wages for Housework movement. And there were interesting groups of women of color who made connections between welfare rights and the wages for the socialist feminist claim of wages for housework. So again, in this historical episode, you see an asymmetry. So you see the elimination of gender stereotypes under law, the individual freedom, as being the feminist solution that really gained traction in law and policy. And then the feminist solution that focuses on the expansion of the welfare state didn't. And I won't go into the historical causation now, but again, you need to look at market conservatism as well as social conservatism to really find the roots of that. So just in conclusion, and I'll talk a little bit more later in our dialogue about how this informs LPE, but coming back to where Reva started with the debates over the infrastructure bill, I think that focusing on some of this labor socialist and Black radical feminist activism that really centered social reproduction provides a point of kind of historical recovery that could inspire our political and legal imagination today, and also understanding the ways in which it was foreclosed and the reasons why provides a historical insight into the crisis of social reproduction in the neoliberal era that we face today. So I'll end there.
Okay. Well, I just want to start by saying I'm so glad to be here, both in this conversation, but also within this language of this world we've all managed to create together, right? The LPE exchanges the last couple of months have been such a source of learning for me. And I want to start my comments by outing myself as not a public law scholar, right? So I could take my space on this panel as a way to think about the first part of what the panel is, right? LPE, inclusion in public law. And so when I started making my comments, I was thinking to myself how I could talk specifically about LPE and inclusion, at least one of which is my main focus of analysis and research. I'm a professor at UCI Law. I write, I think, and teach about law's sort of broad connections to actors and institutions and relationships at the periphery. But specifically, I'm also really interested in sort of queer South's identities, very broadly conceived, to move past the categories of what these things mean. I think so. Today, I want to think through. Part of the reason I'm pausing is because I'm thinking through everything that the last three panelists have said, and all my comments I want to throw away and like redo everything in response to it. But I'm hoping we'll have time to do that. I just want to start by saying this invitation's really made me think about the coordinates of my professional identity, right? So I've been deliberating about what a public law scholar even is. Given the flexibility of categories that each of my co-panelists have been talking about, I think I come from a lens of thinking of law as not public or private, but sort of necessarily public and private in the same way I think of other categories as sort of side by side, right? So local and global is not distinctly different. They're often the same, just the other side of looking at it. And so I'm going to draw from three interrelated projects, two of which have just been published, and one that really has all my mind space right now. The first is a book called Accidental Feminism that just came out with Princeton, and the push of the book is to rethink how regulatory changes at the super meta level changed gender parity in very elite professional work in India. And so it tracks an empirical data point where women following 1991 liberalization in India not just started to enter firms at the same rate as men, but they started moving on and doing very well in very elite stages of partnership at the same rate as their male counterparts. And I argue in the book that it's actually had nothing to do with feminism. It had nothing to do with social movements of equity. It literally was a response to a market change, and it was an incidental response to a larger market change that resulted in this. And I hope that'll give us a way to think about what the role of intention is and how we think through these coordinates of accountability as we think about public law and political economy and its duty to it. The second is a book with colleagues called Invisible Institutionalism. And this book sort of tracks how we consider global North and South, and how words we use, like public, like law, like democracy, like courts, where we face our attention, what we think about this attention has a lot to do with what we consider to be meta scripts and what we think of as useful categories. And I guess it starts to question whether these categories can travel, what the usefulness of them traveling is. And I hope we spend some time thinking through that. And the sort of place where my head is right now is a set of projects that think through what happens when the state actually does the right thing. What happens when the intention is actually good, right? So it sort of expands this understanding of what we think of as identity and care work and who we think of as dependent, to focus on unions that I think increasingly get invisibilized by the law, which is focus on asexual unions or circuits of care, women of color who actually do the work when you're subsidizing what care work ought to be. Who does it fall on? What are the costs of social responsibility? Whose reproduction is at stake when you think about good social reproduction for one set of actors, right? So this is sort of at the center of the kind of project I'm thinking of right now. But mostly it's a recognition of what systems looked like before we had this nuclear heteropatriarchal white middle class centrality, and how more inclusive recognition in employment, in immigration would look like if we were trying to understand these categories. So I know in our introduction comments, we have like 7 minutes. So I want to make sure I just put 3 things on the table. And this comes from all of these projects. I'm happy to answer more directed questions from these projects if that's helpful. The first is sort of, what do we think about intention, right? So what's the commitment that public and private actors have or ought to have to intentionality? What are the criticalities of that commitment? What are its coordinates? Do they have to converge? There's a large sociological theory, that's my training, another outing, that suggests that we really need to think about unintended consequences. It started from Merton, but really it's to think about what good law can do and what bad consequences can happen. I think I'm increasingly becoming interested in sort of success and failure as well. So what happens when good law works? What happens when it's actually a success of a movement? What is the pause then? What is the exit then? The things that have to do with intention, that do intention badly or do harm, but have the clean sheet of saying, oh, we did a really great thing as a state. And now all of the private actors that are actually mimicking our state prerogative are good or meritocratic or progressive or modern, right? You can add another word choice for some sort of success. And I guess I'm interested in that role of intention and how it sort of complicates what looks like good success. The second sort of word I want to place for us to consider is invisibility, right? So what, in short, is law's duty of care to the invisible? And more centrally, what is law's role in creating the invisible? Right, on the one hand, there might still be political incentives to live beyond the normative. As a queer brown person, I definitely feel that imperative and incentive, but exactly for the reasons that it's still beyond the law, right? So what is the usefulness of living in the periphery? But if law is equitable or claims to be equitable, but it doesn't take into account what is not invisible, is it actually doing good equity, right? And I sort of start from the position that the state is always going to be interested in investing in stability, right? So where we look for exits, as other scholars, especially in this group of people, have like argued, you can't look to the state, and I use the word state as broadly confined as possible. You can't look to the state to have the outcome that you really want if what you're looking for is a queering of the periphery. And the interrelated question is sort of how do benefits that flow from the state, right? Like either if you can think of it as like guaranteed basic income, right? Like that we know actually has good outcomes, or private logics like Google actually offering to freeze your eggs and give you a set of what look like equitable progressive outcomes. How do we then think of the trust we place in the state if it doesn't take into account a range of invisible actors, processes, institutions, and how do you keep it accountable if it looks like it's got this clean sheet of doing the right thing? What is a reward for the ideal actor? How do you think of non-ideal actors now that it's no longer just these binaries or categories, now that we're moving away from it? The last point I'll say, and I feel like I have to because it probably is obvious from my comments, but like striking in all of this is this idea of internationality, but also intranationality, right? So public law is rooted in a Western legal tradition, and those logics apply categorically in some ways, but they don't translate seamlessly. What state intervention looks like is very different in different parts of the world. What democracy looks like is different in different parts of the world. I'm actually borrowing from my colleague, Mark Massoud, who talks about how rule of law looks different in different places. So if you're looking for a Western-centric rule of law, you mightn't find it, and that doesn't mean it doesn't exist. And I'm trying to use that framework to think about what good public law or good public law outcomes can look like in new sites, and how do we think of it as good or not? And if we can't, is it even useful to look at these sites within these categories? And the point, of course, is not to disengage, but it's to engage knowing that all of us are going to have to keep modifying the more you add complication to who we're looking at and how we're actually thinking of them analytically. And we're going to get it wrong at times, and we're going to keep returning to the board. And I really hope that's the part of a process like this, right? To like throw out concepts and say, how do we do this better? And how do we sort of have a range of proximities and distances that help us reframe what we think of as good public and what that public even ought to be. I'm going to stop there because I feel like I put a lot on the table, but I look forward to the conversation.
It struck me, Swethaa, listening to you speak, that one of the themes that was cross-cutting in my three co-panelists was really democracy. So maybe I'll just throw out a question there for all of you, which is, you know, how are you thinking about democracy? How does what you're focusing on and its novel nature change the way we conceive of democracy? So just to kind of throw out a few ideas there. Amanda, one question I was thinking about as you were speaking was, you were talking about extending what we focus on when we think about democracy from elections and voting into the media sphere. And I was wondering how bringing media into our definition of democracy might change the way we think about democracy. You know, the traditional way might be the marketplace of ideas, everyone fights for themselves, the majoritarian wins. But then we see all these questions about safe spaces for people who are harassed and the subject of violence. You know, so how are you thinking about what democracy might mean in the media space? And then, of course, Reva's work is dealing with bringing care work into a thicker account of the 19th Amendment. And then finally, you know, Swethaa was making me think about who is invisible, you know, and obviously the way I think about this in relationship to my field is invisible care workers, but who is invisible in democracies, both in the way we think about it in the US and in India and other contexts. So whoever wants to pick that up, it's just a thought I was having.
I also see a note in the chat, which I think actually has synergies to like where you're stopping, Debbie. So Vijayashree is talking about state's intention, which sort of I think connects to like what we think of as democracy and imposition. And actually the phenomenon of imposition was where I started with thinking of how democracy doesn't look and feel or have the same coordinates in different places, right? With authoritarian populism taking center stage in so many spaces. And I'm thinking of the Indian context, but it could as easily be in any other context, right? Like, especially now that we're facing a world health crisis and it is democracy. This is a very popularly elected leader that's rethinking what it means to do good democracy in this context. And I think that good democracy in a context that doesn't valorize it in the same way could make invisible new actors that we don't take into consideration if we don't think of all of these different sides. And I just wanted to add that to the strain of like where you were taking us, Debbie.
What I was about to say is that LPE has primarily focused on, well, if LPE is going to have a public law dimension, it certainly needs to be thinking about democracy generally. I don't know how much of the work that's been done has gone in that direction. I take it that that's part of what Swetha's challenge is. And one way of understanding what Amanda was inviting us to do in her talk, not her account of the field, but her own contribution, was to suggest that in understanding what matters about democracy, it's going to be building out an account of meaningful participation across a variety of domains of life. And it's not going to just be electoral, and it's not going to only be the major media of communications, but it also could involve work, and we can throw in there as well family life, social reproduction, and I'm not sure how many other domains we would add, but it seems that having some reckoning with what democracy means when you run it through those fields of life, it can't be reduced obviously to majoritarianism. So it's going to mean something about the conditions of participation, but it's going to mean some new criteria. That does seem like an important conversation to be having. Am I capturing the strands of what we have on the table here?
Yes, I so much, both you captured what my thinking is, maybe better than my own comments, but I think the question of sort of like expanding our view of where democracy lies and how it should be structured in these new types of spaces, but also in old types of spaces that we in many ways public law has occluded, is the big question. And I think the question is the domains, right? And my suggestion in this work is that we should think through our relationship, not just like with media, but sort of our relationship with this new hybrid of spaces that is both communications and is sort of like the central structures of our economic system, right? And how we should have more meaningful decisional and material voice within them. But also I very much agree, right? like your work is about democratizing the family, Reva and Debbie, right? And questions about what that means. But there's also the workplace, there's your consumer sort of interactions, there's schools. And those sort of like theorizing that is a central set of questions that we have to engage with. In another piece of work, I think about those with relationship to workplaces and consumer spaces. And if you think about like public accommodations laws or Title VII, like part of what they're trying to do is democratize those spaces by ensuring, people aren't excluded. Like that's what that is. And really interestingly, I think, the court at the time interpreted the First Amendment in particular to lean back in a way that encouraged that very form of democratization. And I think it's an ongoing project of what that means, but one that I think should be at least a central strand within what.
I do think that there is an intuition that commerce or exchange is not just an instrumental or a money-making matter, but that central features of human meaning making and belonging are unfolding in those transactions, and that's why discrimination commitments of the Constitution get built out in the major civil rights statutes in those spaces with those kind of key understandings about human dignity attached and not just efficiency. So I'm with you 100%. I think that the family domain is there both in the material as well as the dignitary dimensions, as well as the sort of life chances perspective. I mean, if we're talking about distribution, there's just, there's too many different kinds of significance and of sort of doors and opportunities that are endowments and whatnot, happening both at the beginning and ends of life for us not to pay, very special attention to the ways in which we build out community at those junctures. And I have just the sort of many years of mistrust at the ways in which we do the work of privatization and mystification there. But I guess, so part of the problem is that the metaphors that we use around election and vote counting end up giving us inadequate tools for taking account of what's going on in these other sectors. They're also the same tools that produce the confusion about the work of courts, So as long as we reduce, and this is actually goes back to Swetha's observations again, so long as we imagine democracy as simply majoritarianism, we get into the puzzle about what courts are for, So there's a series of puzzles here that I think need to be revisited, but with the puzzles of the economy in view in ways that they weren't in view before, Go ahead.
Oh no, I was going to respond to that last point you made, because I think that there's an interconnected sort of democratic redress as a way of adjusting power, right? Which is often the way in which we think of, especially within like liberal global north logics of where we delineate this power. And now you're right, it's further complicated by a very democratic populism that's on the rise, right? Like, and if structures are built to operationalize democracy, they're still seen as working, right? But how do they reconcile our considerations of what this democracy is? And I think I take to heart like Akbar's calls to democratize public economy, right? Like, political economy, and what the usefulness of redistributive politics as a way for us to start, right? Especially if you also take into account like larger politics of recursive mutual aid, as Dean Spade would argue, right? But there's a further complication of who speaks in these democratic institutions and what that speech looks like. And sure, it's not just that there are courts, there are also lawyers, there are also lawmakers, and they all go to elite schools and they all, reproduce elite institutions. And so there's an elite social reproduction that happens that can deeply sway or influence what we think of as legitimate neutral rule. And maybe I am talking about the global context, but I think this moves beyond like what we think of as just one particular case, right? Like this idea of what good democracy or working democracy looks like and whose hands it's in. They're still living, breathing actors, even if they're doing work of institutions. And I guess that complicates, again, how we think about this power and what kinds of elite reproductions can still be at stake when we're trying to democratize political economy. And perhaps an approach, I would argue, is to think about democracies in ways that do really thoughtful, recursive communities of care that that are in conversation, that think of it as not as aid, which is really, I mean, this is front and center to me because I'm thinking about how America's response to India's call for the COVID vaccine is like aid is always couched in a we're helping you, this is a public logic because we're doing service, and how that actually reproduces this hierarchy of who's in charge and who has power and who gets to delineate it. And I think we need to add that to our logics of where this power resides and how it flows, because you can't really have a conversation about markets and law and the politics of it without thinking through where that power starts and moves.
You know, another point which builds on what Swethaa was saying is, but moves a little bit orthogonally, is for LPE, one way in which LPE defines kind of what they're doing is, or what we're doing is to recognize the way in which law and politics shapes the economy. And I think to the extent that this conversation is focusing on social reproduction, whether it be social relationships in the media sphere or care work that Reva and I were speaking about, or the COVID crisis and international responses, is to the need to think about the economy as more than a market exchange and more than more than a set of financial exchanges. So I think that distributional politics is really important, but we need to conceive of distributional politics either more broadly or think of something in addition to distributional politics that looks at care, right? So wages for housework is interesting historically to think about this as a heuristic, because the wages for housework claim kind of nominally was give me money for housework. But what it really was more was a paradigm for thinking about the social reproduction of the workforce and what it would mean to support that I think went not in its kind of practical kind of fine tuning, but in its heuristic beyond that, to think about what would it mean to support and justly organized care. So just kind of a call to maybe push LPE a little bit beyond what we've traditionally thought of on the left as distributional politics.
Debbie, say a bit more about it historically, so for people to appreciate a bit of what the movement was.
Yeah, so wages for housework was a movement that actually came out of the Italian worker movement. And it was a challenge both to Marxism and feminism. So the challenge to Marxism was that reproduction, what went on in the domestic sphere, was often thought of as being outside of, as non-productive, because it wasn't producing a commodity like a widget, right? But wages for housework feminist activists said, you know, we are reproducing the fundamental commodity of capitalism, which is the workforce itself. Well, yeah. It was a challenge to feminism because various strands of feminism in the US thought that the kind of gender equity either lay in redistributing housework between men and women or in entering the workforce. And wages for housework said, you know, it accepted on some level the gendered terms of housework, although I don't think it was seeking to entrench them. And it also, from a working class perspective, took note of the fact that liberation doesn't always lie in the realm of employment. One thing I highlight is the relevance of wages for housework for some Black feminist activists who had come out of the welfare rights movement, who were making claims for a long time that mothering, and mothering specifically of poor women of color, was a form of labor that deserves social and state support. So that gives you just kind of a sense of what the movement was. But I think it's interesting to think of it as not purely a distributive claim to money for the housework, but for you know, how can we use it to think about political economy and social justice beyond distribution?
One of the things that strike me as like common threads through a bunch of our work is sort of like thinking, I mean, Reva said, the ways in which, like, social meaning is created in different contexts that bear upon questions of, fundamental participation and what that means. And it strikes me that what we're kind of doing is trying to push back against the idea that there are these either excluded or neutral spaces, be they markets, be they sort of like the international sphere, be it care work, right? That we should sort of like act like either don't matter to the sort of like larger way in which law and political economy work, or are, like I said, like neutral. Instead, we need to think about how, in fact, whether or not you get paid or not as a care worker is something that's really, it has economic meaning, but it has real meaning in both to those people and also within their relationships and how they will be reproduced or not reproduced in the future. And I guess that's part of the thing about the project that I'm working on that I'm excited about is that, I think some of the hope with law and political economy is to reshape, okay, what could these things be if they had more content to them than empty market liberty, right? If that's the only sense of liberty we have, we don't have much, I think. And so what should we have in those spaces that's more?
I actually think that these thought experiments can be quite powerful. And one way of looking at the pandemic was a massive, not just a thought experiment, but suddenly a reconfiguration of social reality, right? So that suddenly people could see it, like visibly, graphically, the public school system was providing a whole network of social provisioning. Take it away, and then what? And there are people marked to be doing certain things, and then what? And will we allow these two worlds to commingle or not? Who's going to pay? What will happen to them? And things have been careening around, and we've been sort of looking and sort of puzzling about how much we're prepared to let worlds converge or not, and who's going to bear the burden of making them manage, making them coordinate or not, and can we rebuild them, and who bears the cost of them? What bears the cost, meaning to parents, to dependent members of the family, to children and children's educations. For how long can we sort of hack something? Children at different ages are bearing the costs in different forms. People in different job categories have borne the cost in different forms, whether in wage terms and health terms. And, we've been looking at the relationships of these sectors. And this conversation that we're having now about the infrastructure bills and the names that are being called about it and our willingness to invest now is really a kind of very, very, very public display with all the status consequences and the stakes in terms of resources and standing and health and well-being, like right there, right in front of us, to see the coordination of these things and to see that in every sense we could possibly mean infrastructure in the sense of what it takes to keep things alive and, the grounds of something. It's right in front of us to look at, but people can just push it away and mystify it like that, and yet we can still model what's at stake in these relationships and just disappear. It's powerful language game stuff, the way it can just go right away again. And you can talk economy and it's not there. And, the work, it's just family, it's just love, it's volunteer, it's not, it's amazingly powerful stuff, It's been actually fascinating to watch. It's not the only branch of my work. I'm writing on the Second Amendment this year, and the court just took a gun case, and I'm writing on the question of courts. And, I could have brought that stuff in here, whatever. But this has been something I've been fierce about since forever. And it feels like a thing that LPE needs to grapple with,
Beyond a thought experiment, it's also actual social, like psych experiments that do basic incomes to families show that women actually have less vulnerability, less, greater capacities to do exit. Like I think two sociologists that did the Mincombe experiment from the 70s recently just came out with a paper about how there's a radical shift into internal vulnerabilities and capacity to make choices within marriages and partnerships. So it's not just that you're giving them money, you're also changing their capacity to be in relation with each other inside this unit that's invisible to you, that you think of as just paying off something, but it's actually doing more work than just that. So it's like, how do we think of non-economic coordinates to what looks like an economic buyout or payout, right? Like that's the real question that we're grappling with. And what do we think of as the implications, not just for the dependents and the actors, but also the institutions that we think are better to build? There's a question in the chat about the pros and cons of state support for this imaginary family. And I think that's so central to the kind of stuff that I've been grappling with right now. And who do we even think of as family, right? So, is it parents and children? Is it only known others? COVID's also, think of thought experiments, forced us into rethinking what these bubbles of care even are, right? Like for a lot of us that, if you're a solitary human that lives in non-asexual, an asexual sort of community, what does that look like? What does together look like? Who's your bubble? Like, is that a new way of operationalizing how we do care work? Is that a new way of thinking through coordinates of community, right? Like that gives us new ways of thinking, I think. But I also just think part of the worry about things like basic income is, what is that income being used to pass on the care work to? Someone's definitely still going to have to do this care work, right? If it's the mother instead of the father, rather than the person you're actually hiring to do that work, like who is paying that cost? Who are we transferring it on to? And how far do you go down that road, right? Like, so is the reproduction happening just in one level of analysis? If you shift that level and you actually add in other kinds of dependencies, what does that look like? And I don't think we need to have definitive answers, but I think rethinking this idea of family and care, but also thinking of who's actually bearing that burden outside of the family once you actually get this payout is also useful to think about the ethics of representation and distribution.
Can I build on that and Reva's last question to ask you all? Reva, you have a paper that I love that I'm forgetting the title of, but it's about sort of like how the tripartite social, civil, political rights was like an intellectual form that sort of was used to push back against the, radical Republican movements for equality in the 14th Amendment, right? And it gets sort of reduxed into the sort of intent and effect sort of distinction within equal protection. And I guess I feel like,
why
what?
Equal protection no longer protects, right?
Yeah, okay, great, okay. I don't know where the link is. Everyone should read this article. It's awesome. Okay, so, but I guess it strikes me that there are similar things happening today. And one of the things that I like about LPE is it points to the public-private distinction. But I think there are other kind of forms of thinking that we need to focus on that are what kind of allows us to slip back. And so I want to ask this directly to Reva. You say that this kind of push to democratize the family happened in the 20s and the 70s. It's now happening today. And what are the ideas and the things that made it not happen? And what does that mean for how hopeful we should be for our present?
Well, the way I've told the story, it's really entangled with political power. I've told a pretty simple narrative in which the question of the democratization of the family is entangled with questions of political power. However, in the 7 to 9 minute version of the story I told, I left out a lot of the backlashes. So every step forward produces a lot of pushback. And so the introduction of the Comprehensive Child Care Development Act in the era that the ERA was introduced in 1970 was, as Debbie knows, an enormous success. It was enacted by both houses of Congress, both Democrats and Republicans. It just was vetoed by Nixon and the beginnings of the new right. And The same thing happened not only in 1971, but in 1976 when Ford vetoed it. And this was like a beginning of a sort of the new right beginning to sort of use not only race, but sex and family to organize conservative themes. And Phyllis Schlafly went to town organizing opposition around childcare. And so, you know, a story here is that it became a lightning rod for all kinds of anxiety. So even though I would say women exercise today more political, you know, they got the vote, but didn't get access to political authority. And they're now getting closer to access to political authority than they certainly had 100 years ago. So one can expect more substantial change, although it was sobering to watch the last couple electoral cycles, the forms of resistance. I was actually exchanging emails today with Melissa Murray about the forms of hostility and rage that women's exercise of political authority trips off in the public sphere. So I think we're closer than we were, but whether that will result in actual measurable entrenched change, that I'm less confident about. We're certainly we're right on the cusp of the unraveling of reproductive rights at the, you know, court. Anything in the federal courts is, you know, at this point gone, not for want of public support, but by reason of who's in our courts. And, you know, so I, you know, part of what's at stake here in the stories that I'm telling is that we have histories that have been largely lost to memory. And were they more integrated into our own self-accountings as a nation, I think that they might provide a better basis for the right that's about to be eradicated. You know, a different account of the nature of our sort of public law might make more central the kinds of rights that the court is about to eradicate. On the other hand, and I'll just say this so that I'm not just sounding so grim, I think that even though the federal courts are now hostile to probably even contraception, I think at the point at which, you know, in another generation, this body of law will be written back, and not just as a bunch of negative liberties, but more on a reproductive justice model that doesn't draw these distinctions between public and private, and does have a more affirmative understanding of rights. And it will be populated, the federal judiciary will be populated by different kinds of judges. And the conception of the Constitution will not be just one that's adjudicated, but will be built out in legislative land, and will be, you know, something that will be an understanding of a project that's to be realized in multiple institutions, not just public, but in private as well as in life, that, you know, in domains that are not just state domains. I don't know how to mark out, you know, the kind of spaces you're talking about, Amanda, in domains that are matter to us, whether or not they're state projects. I guess I want to put it that way. So, and, you know, so that is to say, I'm trying to take, you know, if we don't destroy the planet, I think in a long enough arc of time, there will be different lawmakers there to build back something that tells the story about what it is we're doing in a way that will be decentered from the state and understand the project differently than we now do.
That hope makes me so happy, Reva.
Your generation.
No, Cal's.
I think that small note of optimism is a good way to transition into the formal Q&A period. So I'll just encourage anyone once again to place any questions in the chat. I can get us started with two, and you all can respond as you see fit or not. The first is a few of you mentioned kind of preconditions for democracy, whether in the state realm or in the non-state realm. So I guess I'm wondering how LPE or how you all might think about reaching those preconditions if the preconditions themselves are not necessarily democratically popular, or at least democratically attainable in, you know, our current democratic system. Maybe that should be in air quotes. The second is, I think you each to a certain extent told a story of a victory of rights at the expense of collective power, to oversimplify, and maybe well-intentioned rights. And so the question there is how does that theme and LPE more broadly reveal maybe flaws in traditional constitutional law's diagnosis of the problems it wishes to address and the remedies that it offers? And to what extent can con law and public law be a useful tool, and to what extent can it not?
I've just been talking, so someone else should go.
Well, first, Cal was one of my 1Ls, and I appreciate that he gives really good hard questions. Okay, so I think that those are some of the hardest questions. I guess part of what I take Reva's hope to be, which I share, is that what we understand as constitutional and public law will change. So yes, with its current pathologies, its current understanding of like just negative liberty and negative rights, and oftentimes crude remedies that don't take account of social realities and forms of subordination and forms of identity and relationships, I agree with you. There's a lack, but I think the hope is that we could construct something that doesn't essentially use a one-size-fits-all tool, that the understanding of liberty is just like, a right against state action, but that we can have different forms of rights. They can mean different things in different institutions. We can because we have different social meanings in different institutions that will require us to think through what liberty in them and what participation and democracy in them should mean. And I think that's the whole point of the project, is to resist the one-size-fits-all, I think market-centered notion of liberty. But that's a simple message, right? Like the law and economics movement has been successful because it's easy to understand what like negative liberty is, right? But figuring out what that should mean in other forms of life is, I think, a harder and more ambitious project, and one that I think, will require a lot of person power and thinking.
I can speak just a little bit to the second question. So just to elaborate on my remarks from the beginning of our panel, I mean, I think the conclusion I've arrived at in writing this book project is one that really centers on the limit of anti-discrimination rights in particular. So Title VII, without enhancing labor regulation, gives individuals freedom to work as our economy has shifted from a manufacturing sector to a service and gig economy, and as unions have lost their foothold in the private sector, freedom to work in increasingly exploitative work conditions. And without labor regulation, Title VII can't realize its original goals of inclusion, because those who are most burdened, and when you think of women or LGBTQ persons, people who are most burdened with dependency and care work responsibilities are those who are least able to enter the workplace if it's not otherwise regulated, paid parental leave, more flexible hours and regular hours, etc. So for me, my focus actually hasn't been on the progressive potential of constitutional law. I think I've focused a little bit more on other forms of public law, including, I would put family law in that category writ large. So public family law, like Social Security, I consider a form of family law, and employment and labor regulation. I think an interesting question is how much this divides between courts and legislatures. I don't think it's a simple divide, and I take Reva to kind of constantly push back on that. I think often legislatures had more progressive potential, but I think there is room in anti-discrimination law to advance redistributive agendas. And so, I don't think it's a simple courts bad, legislatures good story. But I've focused a little less on constitutional law, a little bit more on other forms of public law. And I see more in the history progressive potential in both state and federal legislatures than I did in the courts.
Can I add one thing quickly, like off of that, Debbie, is that I think too, it's not just a question of, of law. If our goal is something that's more like a more egalitarian society, right? Then you have to look beyond that, which is like a lot of these things will be about the sort of like social norms, forms of relationships, like relationships of power in these, I'm going to say non-state, whatever, institutions, be they economic or not. And, I think the important thing then is to recognize, I'm going to say what I view as a hermeneutical relationship between those forms of being and like how we think about them in law. Like they're not separate. They like how what you think is family informs, how you engage with the political system, and what we all do informs how it's embedded in law. So I guess I think it's also outside it. Like we need to focus not just on like what constitutional law should be or whatever. I mean, that was part of my introduction, was maybe that's to some degree the wrong field, but instead what we should be thinking about is what type of, social changes we would hope to see. And those may be completely outside of law, but in hopes of making the system, I guess I would say, better in a flowback sort of way. I don't know if other people agree, but.
Could I add? I'm going to just keep adding to that because I think that's what we're doing, stacking here, right? I don't know if this answers your question, Cal, but I have an advanced gender theory class, and we think a lot about sort of this relationship between law, policy, and theory. And so I had a student this year while we were talking about public law broadly confined. I too, Debbie, definitely think of family law as like public law broadly conceived, right? Like that's definitely the way in which to think about it, as at least the way it's set up right now. One of the papers was a student, Sydney Martin, who was thinking of how do you reconceptualize education law from the starting point of analysis as the disabled Black girl child, right? And I offer that as an example to think about what would it look like if we started rethinking rights from the context of the extreme periphery, and then you work backwards to think about what it encompasses rather than adding, right? Like we think of these, so much of law is additive consciousness, right? You keep adding new things and being like, oh, does this fit you? Does this add you too? Does this do good inclusion? Does it do good, is this doing good anti-discrimination? And what if we instead started from the periphery and thought of the most vulnerable actor, and then worked backwards as method to think about where do we look for inspiration? Where do we think of rights as encompassing the most vulnerable, with the expectation that it's going to like actually, include the center if we start there? Just as a method, right? Like I think part of what we're doing here is also thinking through what good frameworks can be to add to this toolkit of how to think through this better and more inclusively. And I just wanted to put that out there.
I guess the last thing I would add is that I feel a kind of humility right now, given the trauma nationally, given where we stand. When I say humility, I mean to say it's obvious that we're in places of brokenness as a community where we don't share common experience or common understanding across really important divides. And we don't have the institutions in which to try to talk with one another about those differences in understanding. And I think that there are deep forms of alienation out there, and institutions that don't do the work of creating bridges or even facilitating healthy argument about them. And that's a really deep difficulty for our system, for our country. No matter where you stand in this, no matter what you're concerned about, because it makes it really difficult to figure out how to get from here to there when you can't have a conversation about matters about which there's such deep division. And I saw some numbers on the Derek Chauvin, sort of polling numbers on the Derek Chauvin verdict, and it didn't really occur to me to think about differences. I should have, different perspectives on the verdict. Of course I should have. I just didn't go there. But of course they exist. And I don't know a place to have a conversation about them. And I don't know, like these matters about which we're just so riven right now, but not just only racial ones. And I think we need to have the institutions where it's possible, because they're only going to get worse. The divisions are only going to get worse, and about almost everything that matters is caught up in our ability to figure out how to have those conversations, not with everyone. There are people that are so far to the edge that there's no point in having the conversations with them, but the people who are caught in the middle, or the next generations of them. So I do think forward thinking about the creation of those spaces, at least intergenerationally, is really critical.
It also strikes me, Reva, that so I very much agree with you, but I think that I don't view the internet as being sort of like the source of problems, but instead like reflecting in many ways, maybe exacerbating some like our existing social cleavages. But I do think, there's such interesting work showing the ways in which polarization has sort of taken root, and in ways that are really pronounced, given the relationships essentially between older forms of media, traditional forms of media, and social media. And I guess one of the hopes that I have is that if you had something that was more like user input into social media policies, that might help as opposed to exacerbate some of that like existing polarization.
I don't have the expertise to know what the settings are. I just know we need creative thinking about them.
Yeah.
All right. Well, I think that's our time. Thank you all so much for engaging in this conversation. It's been really a treat just to sit in and listen to. And I'm sure that all of our audience members feel similarly. And I'm so glad it was recorded, because I think it'll be a worthwhile thing to return to, and maybe Professor Siegel's optimistic prediction will come true in a generation from now, we can hope. So thank you all so much for coming, and thank you all so much for participating.
Thank you, everyone.
Thank you. It was wonderful to get to talk to you.
Bye.